Hi everyone, I'm Neama Rahmani, president of West Coast Trial Lawyers and former prosecutor. Today, I'm going to explain the steps of a criminal case. The first step is being arrested by the police, and that's what starts the criminal process. Once you're arrested, you're going to be taken to jail, where you're going to be held until your arraignment. The arraignment is the first time that someone appears in court, and they will plead either guilty, not guilty, or no contest. No contest and guilty are essentially the same, but sometimes a no contest plea can't be used against you in a civil case. No contest just means that you're not contesting the criminal charges. Most of the time, criminal defendants plead not guilty at the arraignment, which starts the rest of the process. After the arraignment, you and your lawyer will receive discovery. Discovery in a criminal case is one way, which means that the government, the prosecution, has to give you evidence that's in its possession, but you don't necessarily have to provide anything to the prosecution, with few exceptions. So the prosecution has to give you three broad categories. First is evidence that's required to be disclosed under the rules of criminal procedure, and there's many of those. Then there's evidence that is discoverable under the Supreme Court case of Brady. That's evidence that may be exculpatory, which may prove that you're innocent. Last, the government has to disclose evidence under the Supreme Court case of Giglio. That's evidence that may tend to impeach or call into question the credibility of any witness. After you receive discovery, you, your lawyer, and the prosecution may enter into plea negotiations. The government may make an offer, your lawyer may counteroffer, and you're going to see if you can come to some sort of agreement so the case doesn't go all the way to trial. The vast majority of cases resolve by plea agreement or plea bargain, and only a small percentage go to trial. Usually, the prosecution will give you some sort of benefit, like dismissing other counts or recommending a reduced sentence in exchange for your agreement to plead guilty. If you don't plead guilty, and if the case is a felony, one of two things has to happen before you can get to a jury. You either have to be indicted by a grand jury, which is a separate type of jury, or you have a right to a preliminary hearing. I'll start with the prelim. A preliminary hearing is a mini trial before the trial. It's before a judge, not the jury, and the rules of evidence don't necessarily apply. So police officers can come in and testify about what other people told them. That's generally hearsay evidence and not admissible. Then the judge has to determine whether there's probable cause to move forward to the next step. Probable cause is a low standard. It's not that high beyond a reasonable doubt standard that applies in a jury case. It's just would a reasonable juror believe that a crime has been committed. A grand jury is another way that you can proceed to a felony trial. Grand juries are generally used in the federal system and some states on the East Coast. California's state courts generally use prelims, but you can use a prelim in a federal case and a grand jury in a state case. A grand jury is a secret group that meets regularly to decide whether there's probable cause to move forward. And you don't need a unanimous verdict for the grand jury. It's not even called a verdict, it's called a true bill. So let's say there's 23 grand jurors. Oftentimes you only need just a majority or 12 of them to believe that there's probable cause. The important things to know about a grand jury is that in the grand jury room, there's only the prosecutor, the witness, a court reporter, and the grand jurors present. So the defendant and the defense lawyers usually aren't there. And this is important because the grand jurors will only hear a one-sided account of the case. They're not going to hear the defense's perspective. So almost always the grand jury will return a true bill and indictment, and the case will move forward to the next phase. Then you have your pre-trial motions. These are defense and prosecution motions, usually to admit or exclude certain pieces of evidence. So, for instance, if your lawyer is going to argue that evidence was seized unlawfully in violation of the U.S. Constitution, they may file a motion in limine to exclude that evidence, to keep it out. The judge will rule on these types of motions, as well as other potentially dispositive motions like motions to dismiss before the case goes to jury trial. The next phase, and the most exciting one, is a jury trial. If your case makes it all the way to the jury, there's multiple steps before a jury can return a verdict. The first is jury selection. And even though it's called jury selection, it should really be called jury deselection, because the parties, they don't actually choose the jurors, they just choose who is not on the jury. So first the judge will ask questions, and if a potential juror shows bias, the judge will remove that potential juror from the panel. Then the parties get to ask their questions and exercise what we call our peremptory strikes. Those are strikes that can be used for any reason as long as it's not constitutionally forbidden. So for instance, you can't exclude a potential juror based on his or her race or religion or national origin. Once the parties exercise all their strikes, the 12 jurors that are left are going to comprise the jury. And there also may be some alternates, usually anywhere from 1 to 6 alternates based on how long the judge anticipates the case will be. Once the jurors are selected and the alternates are seated, then opening statements begin. The prosecution has the burden, so they go first. They give their opening statement, which is just an outline of what the sides expect the evidence to show. You can't argue your case during opening statements. Then the defense goes. Then the prosecution begins its case in chief. That means it's up to the prosecution to put on witnesses to prove all the elements of the crime. So it can be anything from a murder case to a DUI or anything in between. The prosecution is going to have to put on evidence such as law enforcement witnesses, any percipient witnesses, and expert witnesses to prove their case. Once the prosecution is done and they think that through their witnesses and the evidence that's come in through those witnesses, they've proven all the elements of the crime, it's up to the defense. Now, the defense does not have to put on any witnesses in its case in chief. They can put no witnesses on. They can argue that the prosecution didn't meet its burden, which, as we discussed, is beyond a reasonable doubt. That's the highest standard in the law and what you need to put someone in jail. Other standards that are applicable in some cases are a clear and convincing standard. That's what the government needs to prove to take your kids away from you, for instance. And the lowest standard at trial is what we call the preponderance of the evidence. That's slightly more likely than not, or 50.1%. That's applicable in a civil case. But because it's a criminal case and it's such a fundamental right, the prosecution has to prove everything beyond a reasonable doubt, and they have to get a unanimous jury. Now, one of the big decisions the defense has to make in its case in chief is to decide whether to put the defendant on the stand. The defendant, of course, has a right to remain silent, a Fifth Amendment privilege against self-incrimination. So unless the defendant chooses to waive that right and testify, he or she will not be forced to take the stand. After the defense case, the judge will go over the jury instructions with the lawyers, and once they're agreed to, the parties will begin their closing arguments. This is their chance to argue the case before the jury. They can argue the evidence and the law, and again, the prosecution has to go first because it's their burden. They go first, then the defense makes their closing argument, and the prosecution actually gets a chance for rebuttal to speak to the jury one last time because, again, they have that burden. So the court system gives them that advantage to get the last word in. Then the jurors will begin their deliberations. If they're able to come up with a unanimous verdict with respect to counts, they'll come back to the court and they'll give the verdict form to the judge, and the judge or the clerk will read the verdict. It can be guilty or it can be not guilty. If the jurors are unable to reach a verdict, the judge will ask them to continue deliberating. But if they deliberate for days and they're still unable to reach a verdict, that is a hung jury and that is a mistrial, and the parties and the judge will need to decide whether to try that case all over. After the trial, there may be some post-trial motions to maybe set aside the verdict. Usually the defense makes those motions, as well as the opportunity to appeal. And that's where the case really ends. If an appellate court affirms or agrees with the trial court's verdict, then the verdict will stand on appeal. Sometimes you can appeal to an even higher court like the California Supreme Court or the US Supreme Court, but there's no right to automatically go to the highest court in the state or in the land. Those courts take discretionary appeals. That means they get to choose what cases they hear and what they don't. You only have the right to appeal to the Court of Appeal. If the case is overturned on appeal, oftentimes the appellate court will say, we need to do this trial all over. Sometimes, rarely, they'll vacate the conviction entirely and say there is no opportunity for a new trial. So that's our criminal justice system in a glance. Usually this can take years for a case to go from arrest all the way to appeal, but all these steps are necessary to make sure that a defendant's constitutional rights are protected and the prosecution doesn't potentially convict an innocent person. Thanks for watching. Make sure to like, follow, subscribe, and click the bell for notifications.